Manufacturers have no duty to warn with respect to products manufactured and sold by others. The plaintiff's only claim here is that Ford had a duty to warn with respect to a Ford seatbelt extender used in combination with another manufacturer's product, a Durrell booster seat, in combination with yet another manufacturer's product, a Nissan Juke. Now, the trial court held and actually agreed that Kaufman bars this product combination claim against Durrell, and that separate appeal is pending in this court. We submit that Kaufman logically and necessarily bars the claim against Ford as well, because it involves this exact same product combination. It's the perfect mirror image claim, and so just like Kaufman bars a claim for use of a seatbelt extender with a booster seat, it likewise bars the claim of using a booster seat with a seatbelt extender. But I think it's worth highlighting why the facts of this case are even stronger for dismissal than they were in Kaufman. In Kaufman, the equipment manufacturers, pipes and gaskets, specifically foresaw and intended that their equipment would be combined with asbestos products. And the Supreme Court said it still didn't matter. The equipment defendants still had no duty to warn. And if a manufacturer has no duty to warn when it intends and specifies that its product be combined with another manufacturer's product, then certainly a manufacturer has no duty to warn when it did not intend that combination. After all, a manufacturer has much less reason to warn against every potential unintended combination than intended combinations. And I think that's the logic underlying Kaufman, that there are any number of things that someone can do with your product after it leaves your control. And it's not your duty to warn against every possible misuse or combination of your product. So just like Ford didn't have a duty to warn against using a seatbelt extender on an airplane or on a roller coaster, it had no duty to warn using that extender in another manufacturer's vehicle in combination with another manufacturer's child booster seat. And under Kaufman, it's no answer to say that some of those misuses or uses are foreseeable and some are not. Kaufman carefully considered that argument. The dissent, I thought it was thoughtful and thorough, raised that specific example, and Kaufman rejected that argument. And what Kaufman said is, let's look at the text of the Tennessee Product Liability Act, and it limits a manufacturer's duty to warn specifically to its own product. The legislature could have said, yes, Your Honor.
Let me ask you a question now. Then also, did Ford also notify the sellers to limit their sales and because of this very problem that might exist?
There is a very long history of this case. It's been pending for 10 years. A lot of factual detail that is outside the record. But to answer your question, Ford included a warning on the extender itself that said, essentially, use this extender only if it's physically required to extend your seatbelt. These are made for larger passengers. This specific extender was intended for use in the front seat of a Ford Focus vehicle only, and the extender said use it only in the seating position that it's intended for. There were other warnings involved in the case. For example, the Nissan Juke owner's manual warned not to use a seatbelt extender with a child seat. Our position, though, is that Kaufman sort of makes all of those other issues irrelevant, because Kaufman's clear holding is that it's a bright line rule. A manufacturer has a duty to warn only with respect to its own products, not its product plus some later included product in the language of Kaufman. And the court carefully considered the implications of that decision. Essentially, they held that the legislature could have said that if it is specifically intended that your product is going to be combined with another product, you have a duty to warn, or if it's foreseeable that your product is going to be combined with another manufacturer's product, you have a duty to warn. The court rejected all of those arguments and said, under the plain language of the statute, the duty to warn extends only to your own product. I want to address one other issue, Your Honor, and that's perhaps recognizing sort of the full scope of Kaufman's holding. The plaintiff has attempted to recast their claim for 10 years, literally almost a decade coming up this summer. The plaintiff's claim has been that the allegedly dangerous condition was the combination of a seatbelt extender with the child booster seat. Plaintiff has attempted in its appeal brief to sort of walk back that claim and say that the claim is a duty to warn against using extenders for children in general. We've included in the briefs all of the instances in the complaint where the claim is clearly that the alleged dangerous condition is the combination of the booster seat with the extender. So I think that argument is foreclosed. But I think it brings me to one final important point here, is that everyone agrees in this case that there was nothing wrong with the seatbelt extender itself. If it had been used in the front seat of a Ford Focus to restrain a larger passenger, everybody agrees, plaintiff's experts, Ford, that this seatbelt extender would have performed as it was meant to. And it was only because it was combined with the booster seat that the alleged dangerous condition was produced. That's the specific claim that the Kaufman decision forecloses.
Let me ask you this. So is there never a case where a manufacturer of a product has a duty to warn of a known misuse of its product? I mean, I know that everybody agrees that the extender itself was fine. There was nothing defective with it. But the allegation is, of course, Ford knew that it was being extensively misused as an add-on extender to booster seats, and they knew it by the volume of extenders they all of a sudden started selling and the emails and those things. So there's never a case, I guess then, under your reading of Kaufman, where a manufacturer has a duty to warn of known misuse of its product.
In combination with another manufacturer's product, that's correct. I think that is the fair reading of Kaufman, that, and the court said, we hold. And each one of those holdings says the duty to warn is limited to the manufacturer's own product. The reasoning for that is a textual analysis of the TPLA, that the "it" refers to the manufacturer's own product. It does not refer to later included products. So to answer your question very directly, yes. I think we'll concede that as sort of a policy matter, there are difficult hypotheticals that you can come up with where you would say, surely we would want a manufacturer in this sort of situation to warn about an obvious or a known misuse of the product. Under Kaufman, the reasoning was that the legislature could have made that clear in the statute and did not. And the logic again is that once the product leaves your control, it is outside of your hands, and therefore your duty to warn is judged from your own product at the time it was in your own control. If the court...
So I'm going to get into one of those crazy hypotheticals. Like, I'm pretty sure on hair dryers, there's like a dumb label that says don't submerge in water or something like that. I mean, we all know that we don't submerge an electric product in water. I mean, are they just doing that gratuitously, or I wonder if they're doing that because they know that there are interesting folks around who do weird things and they need to be apprised not to do dumb things?
I think the answer to that specific hypothetical is that the hairdryer manufacturer would have a duty to warn in that situation because it is their own product. It's not a combination with another product.
But it's a combination with water. It's not another product. Their product, if used as intended, is fine. It's not defective. It's
think.
misuse.
I think where Kaufman draws the line is if your own product on its own has a defective, or I'm sorry, a dangerous condition, then you do have a duty to warn. If it's only.
They were using the seatbelt extender not in conjunction with booster seats, but just using it for not a large person. Let's say they were using it for kids, for whatever reason, who knows? They're using seatbelt extenders in the back for kids, not in combination with a booster. There would be a duty to warn there because it's not in combination with another product.
That would be outside of Kaufman's rule, because it's not the combination with another product. That would be presumably another, if it was used in a Ford, right, we would have a separate argument about,
Right.
using it in a Nissan, which is another product combination. But yes, Your Honor.
So you have a duty to warn in a scenario that's less likely.
Well, just duty to warn in a scenario that involves a Ford product acting with a Ford product as opposed to acting in combination with other manufacturers' products. And I see I'm over time. I reserve the balance of my time for rebuttal.
Thank you.
Thank you, Your Honors.
You have your rebuttal. Yes, sir.
Richard Collins on behalf of the Woodruffs. And may it please the court, my friend began his argument with the statement that the only claim that plaintiffs have is a failure to warn claim, that Ford should have warned that the extender should not be used in combination with the booster seat. That is incorrect. There is a standalone failure to warn claim, and that's the one before this court. But plaintiff also claims that the extender was defective and unreasonably dangerous under the prudent manufacturing test, manufacturer test, consumer expectation test, and negligence. So it's not fair to say that the only claim is failure to warn. And furthermore, it's not just about the on-product warnings sewn onto the label. We can prove and demonstrate, and the record does establish it through expert testimony, that the extender, I don't know if I'd go so far as to call it a design defect, but a prudent manufacturer, a reasonably prudent manufacturer, would not have put this product on the market without, one, an adequate warning as to its uses and misuses, or two, designed it in such a way that it couldn't be used in the way that it was in this case, in this manner of prevalent misuse. So this appeal really concerns, it does indeed concern a standalone failure to warn claim, but that's not all that the plaintiff alleges and presents against Ford Motor Company. Now, turning to Kaufman, there's at least a half dozen ways to distinguish Kaufman. This is not a post-sale incorporation or integration case. This case does not involve asbestos. Ford is not a bare metal manufacturer. This is a case of misuse. The words misuse don't even appear in Kaufman. We're dealing with an on-product warning, the adequacy of it. There was no warning in Kaufman. So there are many different ways, but I think the easiest way to look at this case, and the way that Judge Ayler did below, is to focus on the very last substantive sentence of Kaufman. In sum, quoting, in sum, we hold that under the language of the TPLA, the equipment defendants cannot be held liable for injuries resulting from products they did not make, distribute, or sell. Well, Ford argued that it was not the manufacturer of this extender extensively. That issue's not on appeal, but the court found against Ford on that. The court found that Ford was indeed the manufacturer, or at least the apparent manufacturer of the product. Case closed under Kaufman. It was Ford's extender that failed and released Ethan Woodruff during the collision. Entirely different scenario from Kaufman. Now, if we want to look at Kaufman, say, well, what does Kaufman mean? cases, of course, the language of a judicial decision must be interpreted with reference to the circumstances of the particular case and the question that's actually under consideration. Kaufman was an asbestos case. The manufacturers, the original manufacturers of asbestos have all gone bankrupt, or they've settled out in class actions. So the litigation turns to the original equipment manufacturers, these bare metal defendants, as a way to revive asbestos litigation. And states across the country have looked at this. What do we do with it? It's really a public policy question. Are we going to allow these claims? And in Kaufman, even though the opinion doesn't mention it, what was at stake was a simple question: is Tennessee going to follow the bare metal defense? Are we going to be a bare metal defense jurisdiction? And they answered in the affirmative. That's the only thing that Kaufman teaches us. That's it. Tennessee's now a bare metal defense state in asbestos litigation.
If we're looking at broader public policy, though, I mean, if I'm Ford, I'm saying I made a seatbelt extender for one purpose, and that was to extend the seatbelt when it was not big enough to fit around people of a certain size. That's the whole point of our seatbelt extender. If it's used as we intended it to be used and for its purpose, it is not defective. What can we do when someone takes the seatbelt extender and buys it in bulk and puts it on a website and says, hey, you can use this with your kid's booster seat? I mean, how is that Ford's fault?
Well, you can do a couple of things. You can warn against that misuse. You can make it clear on the on-product label that this is indeed for a Ford Focus front seat only for passengers in excess of 400 pounds. You could design it such that it wouldn't go in the back seat of another vehicle. There's a myriad of things you could do. And that brings me to another point. In looking at the record below and what the court found. In, November of 2020, the court ruled on motions for summary judgment related to plaintiff's punitive damages claim against Ford Motor Company and Durrell. And in that order, not appealed, the court says the record establishes that seatbelt extenders are meant to accommodate those few occupants who exceed such weight parameters as the 95th percentile. The record does not demonstrate any other acceptable use for seatbelt extenders. The record further establishes that seatbelt extenders should never be used with child booster seats or car seats. According to the record, the problem is that using seatbelt extenders with child restraints changes the seatbelt geometry and puts the buckle in a bending moment or motion that allows the locking paw inside the female end of the extender to release. And so the metal tongue slips out. Well, that's true regardless of whether or not a booster seat's actually involved or not. What a booster seat does, of course, we can't avoid the fact that there was a booster seat. That's what created the demand. The whole black market was created because of these recessed and pocketed seatbelt receptacles, and parents, and I'm one of them, that have trouble buckling kids in to booster seats now. So that's what created the demand. But they shouldn't be used for children, period, because they change the geometry, because a small child, because it puts the buckle, the weakest part of the seatbelt system is the metal parts, believe it or not. The webbing is what does the work, okay? So when you have a seatbelt extender, booster seat or not, on a child, you've got that buckle, you've got forces imparting on that buckle that shouldn't be there. The whole idea of recessing seatbelt buckles in cars is to put that as low as possible, to get that buckle as close down below the pelvis as possible, because it's safer. And this is a finding that Judge Ehler made. So, significant, we know what seatbelt extenders are for. You can't look at this on product warning label and tell that. We know that parents are misusing it. There's a whole black market that's cropped up to satisfy this new demand. And worse, as Judge Ayler found as well, Ford has knowledge of the misuse of their seatbelt extenders for several years, failed to address the issue. These are findings that aren't on appeal. Now, the idea that, well, it doesn't really matter, foreseeability, these things don't matter. Well, yeah, they do. They matter because that's how we would establish a claim. That's how we would establish, in some instances, a defective or unreasonably dangerous product. If you pursue a negligence theory, well, foreseeability matters. If it comes to reasonably prudent manufacturer test, maybe not so much. Consumer expectation, sure, foreseeability matters in terms of whether or not we're going to say this is a defective or unreasonably dangerous product. Those theories weren't in play in Kaufman. And think about why. The court doesn't get into this, but it doesn't require a whole lot of exegesis to get there. The fact is that how could the plaintiffs against these original equipment manufacturers actually support a prudent manufacturing theory? It's asbestos. Nobody knew back then. Consumer expectations, way too complex a product to pursue that theory. They were left with nothing but a strict liability standalone claim for failure to warn. Well, what does the law say? Well, the law says if it's a dangerous product, you have a duty to warn. What does Kaufman say? Not if it's not your product. That's it. But here, of course, it's Ford's product that was at issue. It's the end product at issue. It's what failed and caused Ethan's traumatic brain injury. You know, if this court were to side with Ford and effectively dismiss this case, I see no way around the fact the court's opinion would have to address prudent manufacturing, how we'd have to distinguish prudent manufacturer, consumer expectation, negligence claims, and misuse claims. We'd have to overrule Upjohn, wouldn't we? I mean, Upjohn requires manufacturers to warn about the dangers associated with anticipatable uses and misuses. It's really that simple. This court should do, frankly, what Judge Ayler did. Look at the last line of Kaufman. What does it say? We hold that these defendants cannot be held liable because for injuries resulting from products they did not make, distribute, or sell. Well, that ends it. That's the end of it. Ethan was injured from a product that Ford manufactured, sold, and distributed. Sold and distributed knowing that its products were being misused. They had actual knowledge, there's argument here, actual knowledge that consumers were using these for children. And they certainly knew of this burgeoning black market out there with the likes of Solomon. They even knew Solomon, the seller in this case, was taking Ford extenders and marketing them for other vehicles. Again, the combinations work, so why not? Ford doesn't warn against that. And of course, Solomon, if we look at his testimony, says, well, the question, how did you come about deciding that you could market these for children? Well, I looked what the major manufacturers warned against. Well, which ones? Ford mainly, because that's the ones, the extenders flooding the market. Well, what did they tell you? They didn't say anything about it, so I thought it was fine. Well, any ordinary consumer would. And that's what renders the extender defective and unreasonably dangerous. This court should affirm the court's denial of Ford's motion for summary judgment on this Kaufman question. Thank you.
Thank you, sir. Your rebuttal.
Thank you, Your Honor. I'd like to address each of the plaintiff's arguments for distinguishing Kaufman in turn. First, counsel argued that Kaufman was somehow limited to asbestos cases. Kaufman could not have been clearer that it was announcing a controlling ruling interpreting the TPLA as a whole. Repeatedly, the court said, we hold that under the TPLA, manufacturers have no duty to warn with respect to products manufactured and sold by others. We hold that under the language of the TPLA. A manufacturer's duty to warn is limited to products actually made or sold by that defendant. The court's holding was a broad interpretation of the TPLA. Plaintiff also argues that this was not a post-sale integration case. Whether you call this a integration or combination, it's really the same thing. In Kaufman, it was just taking asbestos and putting it onto pipes. This is the same scenario here with a combination of products. That's what Kaufman's holding is. Plaintiff argues that, well, the Kaufman facts did not involve a misuse of the product. That cuts against plaintiff's argument. That would be like saying that Kaufman protects Ford if it said, please use these extenders with a child booster seat, but not protected by Kaufman. If it didn't say that, doesn't make sense. That's not what Kaufman holds. Plaintiff also argues that, well, here it's the Ford extender that allegedly failed. So we disagree with that as a factual matter, just to be clear. Our experts analyzed this extender and concluded that it did not fail in this accident. That's a factual issue outside the not relevant for this appeal. But the plaintiff's claim here is that the only reason it allegedly failed is because it was combined with the booster seat. That's Kaufman. That is within the four corners of the Kaufman decision. What we're really hearing today is a foreseeability argument that Ford should have known, based on the volume of these extenders in the marketplace, that these were being misused and should have warned against it. That's the exact same argument that the plaintiffs in Kaufman raised. The court, the plaintiffs and the dissent pointed to subsection 108, which says that a manufacturer is not liable for subsequent unforeseeable alteration, change, improper maintenance, or abnormal use. And they argued that that meant that manufacturers are liable for foreseeable alterations or misuse. The Kaufman majority, 4-1, concluded that, declined to read 108 in a vacuum, and concluded that the whole focus of the TPLA is on the manufacturer's own products and still link a defendant's liability to the defendant's own product, not the product of another manufacturer. So understand that this is a significant sort of point in this case. We submit that the Kaufman decision announced a very bright line rule that manufacturers are not liable and have no duty to warn about the combination of its product with another manufacturer's product. We submit that just like that argument, Kaufman ends the case against Durrell. Logically, necessarily, Kaufman ends this case against Ford as well, Your Honors. Thank you very much.
Thank you. Thank you both for your presentation. Your case has now been submitted to the court for resolution. You should receive our opinion and order within a reasonable period of time.